disorders, its employees and directors assume no responsibility for the accuracy, completeness, objectivity, or usefulness of the information presented on our site. We do not endorse any recommendation or opinion made by any member or physician, nor do we advocate for any treatment. You are responsible for your own medical decisions. Now, I'm going to turn over the introduction of our speaker to Martha Butterfield, the webinar coordinator of NJCTS. Marty?
Thank you, Kelly. Good evening, everyone, and welcome to tonight's webinar. Thank you all for joining us. We are so pleased to be able to bring you the first in a series of 2 webinars on school choice. We begin the series with tonight's presentation on charter schools. Part 2 will be on private schools, and that will be October 26th. These webinars will cover what both charter and private schools are obligated to provide in the way of services for students with disabilities. To present tonight's webinar is attorney Rebecca Spar, a partner in the law firm Cole Schatz in Hackensack, New Jersey. Rebecca has a federal and state court litigation practice covering employment, education, and disability rights law. She served as law secretary to the Honorable David Landau of the Supreme Court of New Jersey Appellate Division. Rebecca is a committed and experienced child advocate who for 25 years has worked to ensure that school districts and both private and charter schools comply with education and anti-discrimination laws and regulations. Furthermore, that they provide appropriate educational services, that they make needed accommodations and modifications for disabilities, and prevent discrimination against those with actual or perceived disabilities. She also serves on the board of directors for the New Jersey Center for Tourette Syndrome and has in-depth experience in the specific issues faced by students with Tourette Syndrome and associated disorders. Rebecca, welcome. We are so pleased to have you present tonight on this very important topic. Now, without further introduction, I'll turn tonight's presentation over to you.
Good evening, everyone. Tonight we're going to be talking about charter schools, specifically charter schools in New Jersey. Now, I know that some of the participants that are going to be here this evening are from other states. So charter schools are formed under state laws. So as far as the formation of charter schools and exactly how the charter school operates organizationally, you need to go to your Department of Education, State Department of Education website, and that will give you the information on that, because what I'm going to be talking about with respect to the state law, New Jersey law, is specific to New Jersey. However, I'm also going to be talking about several different federal laws, the Section 504 and the ADA, and those laws are federal laws, so they would be the same throughout the country.
Rebecca, we are not seeing your slides. Did you click on the button that said show my screen?
Does it do that now? Can you see it now?
No. Yes.
Oh,
there we go. I got it.
Okay.
It's up.
It shows now?
Yes, ma'am.
Okay. So I'm going to give a little overview of public charter schools in New Jersey. Currently, there are 89 charter schools in New Jersey, and they have approved approximately 50,000 seats for the 2016-17 school year. Just to give you an idea of the percent of students in New Jersey who go to charter schools, for the 2014-15 school year, 27% of Newark students attended charter schools. And for the 2017-18 school year, they expect that to grow to 40% of the Newark student population. Now, in setting up charter schools, the New Jersey legislature intended those charter schools to assist in educational reform and to offer educational approaches which were not available in traditional public schools. Whether or not the charter schools in New Jersey are accomplishing that is up for debate. Charter schools in New Jersey are operated under a charter that's granted by the State Commissioner of Education. And they receive funding from the school district from the district of residence where the children are coming from. Generally, they receive around 90% of the program budget per pupil for the specific grade level in that district. And they also get additional state and federal government aid for low-income, special needs, and limited English children. And some charter schools get money from private sources. They are governed by Board of Trustees rather than a Board of Education. And it's up to the Department of Education to decide whether they're going to remain open or will be closed. Now, it's important to know that charter schools are public schools in New Jersey and in most states around the country. And in New Jersey, charter schools have to comply with all of the laws and regulations which govern other New Jersey schools pertaining to assessment, testing, civil rights, and student health and safety. Now, are charter schools required to provide services under the IDEA or the Individuals with Disabilities Education Act? And the answer is yes. They are governed in New Jersey by the same federal and state requirements concerning special education services as other public schools are. Charter schools also have to comply with all federal and state civil rights laws. And this includes laws which prohibit discrimination against students with disabilities, such as Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. Now, the question comes up as to how students are admitted to charter schools. Well, each charter school has its own admission process, but generally a student has to be enrolled in the district of residence, and then the student requests to be moved to a charter school. Charter schools have to give preference to students who reside within that school district where the charter school is located, and they can give preference to siblings of existing charter students. Now, if there are more students that want to attend a charter school than they have openings, then they are supposed to hold a lottery and create a waiting list. And this is important information to know. Now, if you want to send your child to a charter school that's not located in your district of residence, then you have to contact that charter school. You have to look at the school's charter and see what it was approved and which students it can take and under what terms. Now, if you're coming from your district of residence and going to a charter school within your district, then no tuition can be charged to your child. As far as transportation is concerned, the district of residence is required to provide the transportation to and from, and that would be under the same terms that would apply, you know, as far as mileage and so on is concerned. Now, if your child is classified and needs transportation as a related service, then that would be included within the child's IEP. and the IEP would include any special requirements, such as if your child needs air conditioning or a bus aid or particular type of harness or anything of that sort. So that would be the same as if your child were going to the public school. Now, as far as restricting admission to students because of their cognitive ability, their disabilities, charter schools cannot restrict admission on those for those reasons, because of race, income, special needs. They can't discriminate on the basis of intellectual or athletic ability or achievement. For example, your child should not have to score at a certain level, aptitude, anything of that sort, being able to speak English. Now, some charter schools are specialized schools, so they only focus on math or science or arts or particular grades, and that they can do, but they cannot restrict the admission. Now, a question that often comes up is, do I have to tell the charter school when I apply that my child has a disability? And the answer is no. Once your child has been admitted, and before they begin, you want to make sure that the charter school has the IEP and any other needed information. Now, your district of residence should provide that information to the charter school, but in case they're slow in doing that, you want to make sure that before school opens, they have that information. So what happens, and one other question on the admission is, do I have to put on the admission form that my child has a disability? And the answer to that is no. And if you are asked that information before your child is accepted, you should not have to answer until your child has been accepted into the charter school, because otherwise there may be a tendency to limit your child's enrollment, which would be wrong. Now, if your child is eligible or might be eligible, the question comes up as far as what is required of the charter school with regard to the Individuals with Disabilities Education Act. And the answer is exactly the same thing is required that is required of your public school district, with one exception, and that is, and we'll go into that in more detail later, but if your child needs a private school, either a day school or a residential school, specialized school, then there is then the public school district has to pay for that rather than the charter school. But otherwise, the charter school has to evaluate children, has to identify children who may have a disability, has to prepare your individualized education programs, so your IEPs, has to provide an appropriate education. It needs to be in the least restrictive environment, has to provide all of the related services, and has to provide a continuum of services, which means being able to educate your child in a general education class, in resource classes, in specialized classes, having the full continuum of services. Now, if your child has an IEP or had an IEP in his district of residence and is then admitted to a charter school, then what would happen when he starts there, he or she starts there, is the child study team in the charter school should review the IEP and any other documentation that is provided, evaluations and so on, and in consultation with you, should provide a comparable program to whatever is set out in the IEP. And a comparable program would be if your child had in-class support services in the public district, in the district of residence, and had speech and occupational therapy services, then they should have the same services in the charter school. Now, if after your child gets there, the charter school does not want to continue to implement that comparable program, it has to conduct any assessments that it believes are necessary and develop and implement a new IEP within 30 days of entering the charter school. So in other words, it could do an educational, psychological, other evaluations, and hold an IEP meeting with you and say, going forward, this is what we want to do. Now, if you don't agree with that revised IEP, you can file mediation or due process, and your parental rights booklet will tell you how to do that. Or you can get on the New Jersey Department of Education website, and it will tell you how to do that. You do not need an attorney necessarily to file mediation. You can have one if you want. But if you do that within 15 days, then within 15 days of receiving written notice of the changes to the IEP, then the charter school has to continue to implement that comparable program while the mediation or due process is being decided. So this is something that is very important to do if you want to keep those services while you discuss this with the charter school. So you need to file within 15 days of getting written notice of the changes to the IEP. Now, another thing that happens sometimes in charter schools is your child goes into the charter school, is classified and receiving services in the district of residence, and sometimes this has been going on for a number of months, and is reevaluated and told during the first few months of school that the child is no longer eligible. So this is not just a change in the IEP. The charter school is saying that your child no longer meets the eligibility requirements. So again, if you file for mediation within the 15 days of receiving your written notice that your child is being declassified, and this, you will be told this at a meeting, because they will hold a meeting to review the evaluations, and they will tell you at that meeting that they are recommending to declassify your child. Then if you file mediation within 15 days, then the charter school has to continue to leave your child classified and provide the services while the mediation takes place and any litigation is completed. And again, this is important to do this within the 15 days so you can keep the services while you discuss and go through mediation due process with the charter school. The other thing you can do, in addition to filing within 15 days to keep your child classified, if you don't agree with the evaluations that the charter school conducted, you can inform the charter school in writing that you don't agree, and you request an independent evaluation at the charter school's expense. Now, you don't have to go into why you don't agree. You just have to say, I don't agree with the charter school's evaluations. I want an independent evaluation. The one thing that you do have to do in your written letter, you have to list the kinds of assessments that you want done. For example, a speech, a neuropsychological, neurological, functional behavioral assessment, educational, all the different kinds of assessments. Now, you can ask in your request for independent evaluations, you can also ask for types of assessments that the charter school never did. For example, and I've seen this happen where the child goes in, the child has ADHD, is classified by his district of residence, gets to the charter school conducts educational and psychologicals and says that the child is no longer eligible, does not conduct a neurological to assess whether the child does in fact have ADHD, and then says the child is not eligible. So you can request and list as one of your assessments a neurological or a neurodevelopmental or whatever kind of medical doctor that to evaluate and see whether your child has ADHD or not, or continues to have. Now, in addition, you can inform the charter school in writing that you want a Section 504 plan developed for your child, because as we're going to discuss, you can get a free appropriate public education under a Section 504 plan as well as under IDEA. So if, and we'll discuss why your child might not be eligible under IDEA but can still be eligible under 504. So you can do all of these things, and you can do them, just do them in writing and make sure the charter school, that you can confirm that the charter school received your written request. Now, what if your child starts off in the charter school and then you find out they're not classified but they need more support than they are receiving? The federal and state regulations list Tourette syndrome and attention deficit hyperactivity disorder as disabling conditions under IDEA, under the category of other health impaired. So if you are diagnosis with one of those or other associated conditions, then it's probably going to fit under other health impaired. Obsessive compulsive disorder could be covered under there, even though it's not specifically mentioned in the regulation or statute. Now, in addition to having a disabling condition, the condition must adversely affect educational performance. And educational performance has been broadly construed by most courts to include not only academic performance, but also behavioral, social, emotional, and communication. So it's much broader than how it is sometimes interpreted. And you can help your school understand how your child's TS or your associated disorders adversely affects your child's educational performance, because sometimes they need help in figuring out how it does affect. So you need a disabling condition. It needs to adversely affect your child's educational performance. And the final criteria, and the one that sometimes means that students are found not eligible, is that they must need special education. Now, special education is not a place where your child is going to be educated, so it's not a special education class. It is not a special education teacher necessarily. Special education means specially designed instruction to meet your child's unique needs. So it could be adapting the content, the methodology, or the delivery of instruction for your child. And of course, it's to address the unique needs of your child and to ensure access to the general curriculum. So an example would be, let's say your child has TS and ADHD, and it is agreed, the IEP team along with you agree that your child needs a one-on-one aid to refocus him when he's in the class, and then to go with him when he needs to leave the classroom because of his tics or his ADHD. And the teacher can make teacher notes available, can provide material to the aide so she can work with him when he's out of the classroom. Teacher can break the assignments down into manageable parts and meet periodically with the student to either make up the work or make sure he's on target with the assignments. So that can be special education, even though the teacher is a general education teacher, and the child is remaining within the general education classroom. Now, I'm not saying that this is something that every child with TS or ADHD is going to get, but these are the kinds of services that could be construed as specially designed instruction. Now, other examples would be if your child has TS and a reading disability or some other disability and needs to have a special education teacher come into the classroom to support him in a general education class. So in that case, you have a special education teacher, so there's usually not much of a dispute over the fact that your child is getting specially designed instruction. And another example would be where the child really needs to come out for one or more classes, maybe to a resource room, to a smaller environment, sometimes for individualized instruction. So all of those are examples of specially designed instruction that a child might get. Now, what if the child needs an aid and the charter school says that it doesn't provide aids? Well, a charter school, like the public school, your district of residence, has to provide the services, the supplementary supports and services that your child needs to meet his unique needs, and so that he can receive an appropriate education in the least restrictive environment. So it is a violation of IDEA to say that we're just not going to provide aids because we don't do aids, or we don't do ABA, or we don't do this type of instruction or this type of service, because they have to provide the services that your child needs. Now, your IEP team may decide that your child doesn't need an aid, and that would be fine, but they can't just give a blanket no. Now, another area that comes up in charter schools is, what if your child needs an extended school year? And a charter school, like the district of residence, has to provide an extended school year if the student needs one in order to receive an appropriate education. And there is no single criteria. The criteria that is most often used is what is called regression and recoupment, which is the first one on the list here. But there are many, many other criteria that can be used to provide or as rationale for an extended school year. Either your child has made very little progress, has very severe disabilities or a very severe disability in one area, has missed a lot of instructional time, and the skills are just emerging, and so on. So there are a lot of different reasons that an extended school year is warranted and should be provided. Now, one thing, sometimes the extended year program consists of paying for a social skills program for the summer, because sometimes that is an area of real need that needs to be addressed during an extended school year. Sometimes the extended school year consists of related services, OT, PT, speech, which need to be continued. All right, another area under IDEA is, what if your child wants to participate in extracurricular activities such as basketball, but needs accommodations or modifications to do that? Well, under IDEA, students are entitled to aids and services that they need in order to have an equal opportunity to participate in non-academic and extracurricular activities. Now, by non-academic would be some of the, some of the specials that happen, some of the electives, some of the, those kinds of things in extracurricular activities. So if they need accommodations, then they should be given. If they need supports like an aid, then that would be given. Now, one thing that occurs with children with Tourette's and other kinds of disabilities like chronic fatigue syndrome and so on is that there are time periods that the child, either the tics are so frequent and pervasive that the child is unable to attend school, but other times is able to attend. So this can be taken into account under IDEA in preparing the IEP and the kind of services that the child would need. Now, if your child is only going to be out for a day at a time, and this happens, every 6 weeks or so, then what you might need to do would be to set up that absences won't count off, so that if there's a maximum number of absences, that wouldn't apply. Schoolwork's going to be sent home, those kinds of things built into the IEP. If your child is out for longer periods, where it's a week, 2 weeks, 3 weeks at a time, the child's IEP can be set up so that this is planned for, so that if the child is going to be out more than 3 days in a row or something, whatever is set within the IEP, then someone will come to the home and work with the child or work with him individually when he returns to school, but there will be a plan set up within the IEP. And often schools like to say, well, if you're out, you have to go through a home instruction, and that's a whole different set of rules and regulations to get home instruction. But it can be built into the child's IEP if the need for that is because of the disability that the child is receiving the IEP services for. All right, the one exception where the charter school does not fully control the IEP and the child's placement is when the charter school IEP team decides that the child needs placement in a private, specialized day placement or residential school placement. Then the district of residence is responsible for paying for the cost of that placement, not the charter school. So, for example, if you live in Ridgewood and you're going to a charter school in Ridgewood, and you need a private day or residential, these are specialized schools we're talking about, then Ridgewood is going to be responsible for paying for it. The charter school IEP team, along with the parent, decides that the child needs the private day or residential placement. And within 15 days of doing that, the charter school must notify the district of residence that it is proposing a private school. And the district of residence has 30 days to decide whether it's going to challenge it, the proposed placement. And the way that it's not clear from the regulations exactly how this challenge should take place, but some administrative and court decisions have interpreted it to mean that the district of residence is going to file a due process petition in the Office of Administrative Law. They will file it against the charter school and the parent to do something different other than agree to the private day placement or residential placement. The something different may be the district of residence may propose bringing the child back into the district and propose a particular placement. They could propose another public school placement. So what they propose is up to that district to work out. All right, so that really covers IDEA within the charter school and some of the things that may come up under IDEA. You also have the federal law, which is Section 504 of the Rehabilitation Act, which is a civil rights law that prohibits discrimination on the basis of disability. Now, you can get a couple of different areas can be covered under 504. The first one is if your child is not eligible for services under IDEA, usually because he or she doesn't need special education, the child still may be entitled to an appropriate education in the least restrictive environment under Section 504. So that is something to keep in mind, and that's why I said if your child gets declassified in a charter school under IDEA, then you can send a written request. Even if you're going to argue over if he shouldn't be declassified under IDEA, you can make a written request that the child be found eligible for services under 504. Now, the difference to the charter school is they get no state or federal additional funding for a Section 504 child. They still get their 90%, but they don't get the additional state or federal funding that they get for IDEA, under IDEA. Now, Section 504 also prohibits discrimination based solely on a child's disability in any programs or activities receiving federal funds. And so all public schools, including charter schools, receive federal funds, so they all are covered under 504. So the anti-discrimination portion of Section 504 can apply to children receiving services under IDEA, as well as to children who get no services under IDEA. Maybe they don't get an appropriate education under 504, but they still have a disability and they still are protected against discrimination. So Section 504 requires schools to offer students an equal opportunity to access the benefits available to non-disabled students. And Section 504 also requires schools to offer non-academic and extracurricular activities in a manner that is necessary to give students an equal opportunity for participation in such activities. So that is similar to what they are entitled to under IDEA. So some of the areas that are discrimination that would protect your child, even if your child is getting services under IDEA, would be, for example, your child has a variety of different disabling conditions. She has the skills to participate in an honors algebra class, but she needs some accommodations, and the school says it will not make any accommodations for students in honors classes. This is still common, even though it is consistently found to be discriminatory by the Office of Civil Rights. So if now your child may have to qualify for an honors class, but if they do, then they're entitled to accommodations and, that they need in order to succeed in that class. Your child has vocal tics, and the school says he can't participate in school trip because his tics are too disruptive. That would be discriminatory. Your child needs to take medication on a school field trip, and the administration says, well, we don't have a nurse to send, and so therefore either you have to go or your child cannot attend. That's discriminatory. Your child has food allergies and needs a plan to deal with possible anaphylaxis and for the eating, and the school says it can't do it, it can't meet your child's needs. That could be discrimination. So those are some of the common examples of discrimination. But if you say to yourself, my child is being discriminated against because of his disability, then Section 504 is something you might want to consider. Now, Section 504 has different eligibility requirements. So your child may be eligible, even if he's not eligible under IDEA. And the first thing that you need to keep in mind is that in determining eligibility under 504, the school cannot take into account any mitigating measures that your child is using, such as they have to look at how your child would be without medications, without accommodations, without modifications, and even without using any of the compensatory strategies that he or she may have learned to use. And they cannot require your child to use any mitigating measures like medication in order to attend school. So that is very important, because when you take all of those things away, then you really are getting back to looking at what impact the disability has on your child. So to be eligible under 504, your child has to have a physical or mental impairment which substantially limits the child in one or more major life activities. And there are two other ways I list there, but these are going to rarely occur in public school setting. Physical or mental impairments really includes almost any diagnosable condition, unless it's one that nobody agrees is really a diagnosis. I guess that might not be covered. But it covers TS, attention deficit, all of those associated disorders. So usually that is not the issue. You have, in addition to the physical or mental impairment, it has to substantially impair the child. And the law says that this is to be interpreted broadly, and if there's any question over the impact, it's supposed to find in favor of the child. So even though substantially impaired looks like a bigger thing, it is not under the law supposed to be. Now, in determining whether the disability substantially impairs your child, you don't look at how well the child does in that, but rather how the disability impacted the major life activity. So if you were looking at somebody, for example, who had an orthopedic disability, you don't look and say, well, they could run the big, the Boston Marathon, so therefore it's not impacting their running. But how, what did they have to do in order to do that? How did it impact that major life activity of running, and so on? So you have to look not at the outcome, but how it really impacted their engaging in that major life activity. Now, with a child with TS, the child may be in a regular classroom, may be earning good grades, but he often has to leave the class because of his tics. He misses instructional time. He can't finish his homework at night sometimes because his tics are so severe. So those are how that impacts his major life activity. The fact that he ends up getting good grades, that's great, but that doesn't mean that it's not substantially impairing him in his learning. He's missing instruction time. He's missing being able to complete the homework. He has to make it up at some later time. So it has to substantially impairs him in that major life activity of learning. Now, major life activities for children who are kindergarten through 12th grade do not only consist of learning. And this is very important to keep in mind, because sometimes schools think the only major life activity we have to be concerned about is learning. That's not so. Even if it doesn't impact learning, it may impact other major life activities. And major life activities are really attention, walking, sleeping, talking, breathing, eating, attending school. It also includes conditions that impact your major bodily functions, such as cardiovascular systems, immune systems, or digestive systems. So it's really very broadly defined. So if your child has ADHD, which limits the ability to focus or attend during classes, that is, being able to attend is arguably a major life activity, and so it is substantially limiting. So that is Section 504, that you need a physical or mental impairment which substantially limits you in a major life activity. And of course, if you need special education-related services, that could be available, and it prohibits discrimination against you solely because of that disability. Now, another federal statute is the Americans with Disabilities Act, Amendment Act of 2008. Now, in 2008, the ADA was amended, and it was amended because the United States Supreme Court had enacted several, had issued several decisions which narrowed the the breadth of what was covered in the ADA. In other words, it covered fewer and fewer people based on these decisions. And so Congress went back and said, no, this is wrong. They overruled those decisions, and they broadened the ADA, and at the same time they said certain of these changes, and the important ones that we've talked about, are going to also apply to Section 504. So whenever you are involved in cases involving Section 504 or ADA in schools, you need to keep 2008 in mind, because some schools have still not caught up with that, and they're still applying the narrower law. For purposes of K through 12 students, the ADA and Section 504 are very similar. The ADA doesn't specifically refer to an appropriate education, but it prohibits discrimination similarly to the 504. One difference is that 504 prohibits discrimination solely because of the student's disability, while the ADA prohibits discrimination when the student's disability is one of the motivating reasons for the school's action. Sometimes this is important because the school comes up with reasons, well, we did it because of this, we did it because of that, and the disability was only one of the reasons. Well, then the ADA may come into play. Another important thing that the ADA does that 504 doesn't in the same way is that the ADA requires schools to ensure that communication with students with disabilities is as effective as communication with students without disabilities. And this is of major importance to students who are deaf, who have autism, cerebral palsy, or other disabilities where their communication is very, very limited. And so the ADA says, well, you have to provide auxiliary aids and services so that the student that communication with these students is as effective as communication with non-disabled students. And this allows students to get services that they may not be able to get under IDEA, because IDEA says you have to provide an appropriate education, but it doesn't say it has to be as good, or at least it's been interpreted to not say that it has to be as effective as the education provided to non-disabled students. All right, those are the state laws, the federal laws, I'm sorry. The Section 504, the ADA, and the Individuals with Disabilities Education Act. Now we're going to look at a state law, a New Jersey state law, which deals with bullying, harassment, or intimidation of students. Now, New Jersey's HIB Act, as it is called, Harassment, Intimidation, and Bullying, prohibits harassment, intimidation, or bullying by other students or by staff members in all public schools, including charter schools. And this New Jersey's HIB Act is very broad. It not only prohibits harassment, intimidation, or bullying because of a disability, or because of race, or because of any other protected group, it also prohibits it because of a perceived characteristic. So in other words, if you have red hair and you are being bullied in school because of your red hair, even though you are not disabled, you are not from a protected ethnic group or race, you still could become under New Jersey's HIB Act. And so charter schools have to have a HIB policy and procedures, and so you ask them if they don't give it to you, ask them for a copy. And it sets out, you have to have an investigation. You fill out your complaint, you get an investigation within 10 school days. They then report to the superintendent or their head, and they decide the actions to take, and then they inform you within 5 days of the report to the superintendent as to whether a violation was found and whether disciplinary interventions were imposed. And you have a right to appeal to the Board of Trustees and get a private hearing. Now, if your child is accused of bullying, harassing, or intimidating somebody, you may also appeal that decision to the Board of Trustees, and you get a private hearing to appeal it. And as if you are the parent of a student who has been accused of bullying or harassment, you get a written notice that your child has been accused of bullying or harassment, intimidation. Now, I just thought you'd like to see some of the examples of HIB violations that have been upheld by the New Jersey Commissioner of Education, because the route is you go through the Board of Trustees for an appeal, then you can appeal to the New Jersey Commissioner of Education, who could assign it to the Office of Administrative Law for a factual hearing. A student called another student a horse and a fat ass. That was upheld. A student said another student sucks at basketball. That was upheld. A student said another student was the one in the school that had lice. Everybody knew someone had lice, but this little boy reported that it was a girl. And a student made disparaging remarks about a classmate who was vegetarian. So you can see that these are not what we would typically think was discrimination, but it is a perceived characteristic, and so it's covered by the HIB Act. Now, your child can also be protected under other 504, the ADA, and the New Jersey law against discrimination, and may also be covered under IDEA if your child's education is being impacted. For example, if your child's grades drop or he doesn't want to go to school, and you can see that it's actually impacting how he's receiving his education, you can ask for an IEP meeting and see if changes can be made to the IEP. All right, the next area that I want to cover is on discipline. And discipline in charter schools can be an important area. All charter schools have a disciplinary code. They have to have one under their charter, so you need to get a copy of it, and so that you are familiar with what it is. Now, if you think, and because some of the student codes are quite comprehensive and detailed, so what do you do if you believe that the student code is penalizing your child for behaviors he's exhibiting because of ETS or other disabilities? Like he has vocal tics, so he sometimes calls out, and his teacher takes points off for that behavior, and you have to have a certain number of points, or else then you get penalized more. Or you lose points if you don't give eye contact and you're autistic, or you get points taken off because you don't pay attention, because you're impulsive, because you forget to turn in your homework, or other behaviors that may be coming out of your ADHD. So arguably, this student code could be discriminatory because it is disciplining your child for behaviors that are arising out of his disability. So you need to make sure that the school is aware of your child's disability, even if they're not getting other services. Ask that modifications be made and that the student not be penalized for those behaviors. And the modifications can be a part of the IEP or the 504 plan. Now, you could also include in the 504 plan or the IEP strategies when it makes sense. You can include strategies to work on increasing the child's ability to attend. Now, in a charter school, your child has the same procedural protections as if they were attending the district of residence. I mean, if they are going to be out for more than, whether they're classified or not, if they're going to be out for more than 10 days, they have to hold a Board of Trustees hearing. They have to provide services after they're out for 5 days. So the same rules apply that would apply if they were attending the district of residence. Now, if your child is classified, then before the charter school can change the child's placement, and it would be a change of placement if they are out going to be suspended for more than 10 days in a row, or if they have been suspended during the school year for more than 10 days, and there's a pattern to the suspension. In other words, they are being suspended for similar behavior within a shorter period of time. Then the school has to have what they call a manifestation meeting, where they're going to determine if the behavior is a manifestation of the child's disability. Because if it is, they cannot discipline him. And they also have to conduct a functional behavioral assessment to determine if the function of the child's behavior and prepare a behavior plan. So this meeting is an important meeting. You need to go. You need to get all your outside specialists to have input to show how the behavior is caused by or has a direct and substantial relationship to the child's disability, or is a result of the failure to implement the child's IEP. Because if it is a manifestation of the child's disability, and I've given some examples here, then they cannot discipline him. They have to return him to school. And of course, you have a right to challenge the decision if they say it's not a manifestation, and you again can file mediation due process. Now, there are circumstances, and if a weapon, illegal drugs, inflicts serious bodily injury, where the charter school, like your district of residence, can remove a child for no more than 45 calendar days, and they have to provide instruction. And you're entitled to written notice. If the suspension is more than 10 days, you have a right to appeal it if you think it's too harsh or isn't warranted at all. One other point is, in New Jersey, you can expel children, students, based on criteria that are set out in the law and the Board of Trustees. However, all children in New Jersey are entitled to receive educational services within 5 days of any suspension or expulsion, and you get 10 hours per week of one-on-one home instruction on at least 3 days per week. So you are not cannot be left legally without any educational services. One final note, New Jersey Center for Tourette's Syndrome has many, many services to children with Tourette's and associated disorders, but I think one very important one that pertains and can be very useful with charter schools is they will send students with TS and adults to schools to meet with students and or teachers and educate them about TS and associated disabilities and possible accommodations and modifications. And this can be a wonderful, wonderful in-service for students and for teachers. So that finishes my presentation, and I think we will go to question and answers.
You bet we will, and we have a few of them. Just let me get my proper window open here. Okay. So I'm going to start with a question regarding manifestation. Is there any relevance to what you said there? If the student is in elementary, middle, or high school, are there any distinctions there due to age?
Well, there would be a distinction between what one would expect at different ages, of course. I don't know if I mean, the manifestation is supposed to be, is it a manifestation of his disability? But what one would expect of a child at different ages varies.
Well, sure enough, but in terms of how that the manifestation is, how the disability is manifest, I'm struggling with that word now. But so the distinctions then shouldn't make any difference whether the child is in elementary, middle, or high school then, in terms of how they would perceive the manifestation, I guess is a good way to say that.
Well, I don't think, if I understand the question correctly, I don't think it would. I mean, how the disability manifests itself is going to vary, but that's specific to each child anyway.
Yeah, but if you had a kid that was like acting out, let's say, and had verbal outbursts, let's say there was some OCD or attention deficit going on there, and the student is elementary school, so it has a particular kind of outburst, let's say in elementary, but in high school it could be a very different kind of outburst. So in that example, is there some other issue there that they're going to take a look at given the age of the child or the student?
Well, but the of course the outburst is going to be different depending on the age, whether they're in elementary school or high school. But still the question goes back to, is that outburst a manifestation of the disability, or is it coming from something else, unrelated to the disability?
Okay, so that would just have to be determined then. In
right.
That case. Yeah, okay. What if there is no charter school in your district? Do you get a preference in a neighboring district? How does that work?
To my knowledge, you do not. To my knowledge, you'd have to you would have to see if any of the charter schools in other areas, what their requirements are for accepting students from other districts. But no,
because
I'm not aware of any way
okay.
that if there's a charter school in your area, you get preference elsewhere.
Okay. It seems, though, that those numbers, particularly in this case in New Jersey of Newark, they were really high in Newark, the number of charter schools. So right. It would seem that a lot of them are in urban areas versus
right.
outside of cities.
Right. Well, I mean, there may be a variety of, I know there are a variety of reasons for that. Some communities object strongly to having charter schools in their areas. Some want more charter schools, and the state has put more emphasis on bringing charter schools, to schools.
Not urban schools then, yeah.
Yeah. So it's not, I mean, charter schools are not equally distributed throughout the state.
Yes, I can see that when you look at those numbers in Newark. So have a question about a charter school. So the charter school and the parents agree the child should be placed in a residential placement, and the home district is not in agreement and challenges the decision and has 30 days to do so. What happens to the child during that 30-day period?
Well, the child is going to stay where he or she is.
Okay, so if they're in the charter, then they're going to stay in the charter for that 30-day period.
Right. I mean, the parent can always remove them from the charter and register them back in their home district, but I mean, that's always up to a parent, or at least most parents. I mean, Newark has special rules for that, but generally speaking, a parent can do that.
Okay. Do charters typically go K through 12?
It varies depending on the charter school. Depends
Okay.
on how, what they've worked out with the state, what their charter says.
All right. So are there charters then that would be just a high school? So you would go K through middle school in a, in a
There
one
could
charter
be,
and then
yes.
move to another one?
Yes, there could be.
Okay.
There can be. I mean, if people are interested in what charter schools are available, they can go on the New Jersey Department of Education website and get information about charter schools. And another thing that if you are interested, and I didn't bring this up, but if you are interested in a particular charter school, you can go on the New Jersey Department of Education website. They have a whole section devoted to charter schools, and they also can collect data about the charter schools, such as, how many students with disabilities they have, how many, what are the ethnic groups, how many of them went on to college, how they did on this standardized statewide assessment.
So that's one of the questions I have here about how that transition works from high school into college for kids in charter schools. So that information is also available through the Department of Ed website then.
Right, right.
Okay. How is mediation handled in a charter school if English is not the primary language at home?
Right. Well, mediation you file with the New Jersey Department of Education.
Okay.
And at the time that you file, if you are going to need an interpreter, you would want to make that known to them, to the New Jersey Department of Education at the time that you're filing.
Okay. And so who pays for that interpreter then? Is the
well, the
parent?
state would pay for it.
The state would pay. Okay.
Right. Right.
The paperwork that you get when you've got this, you're talking about this 15-day mediation time that you have to reply with for this mediation. When a family's going through this, there's a lot of paperwork that goes back and forth. And how clear? What happens if you miss that 15 days? Like, what happens then?
Well, after 15 days in New Jersey, the school can implement the IEP or the change in classification. So, it's best to err on the side of doing it too soon rather than too late.
Too late,
yeah. If you go to a meeting, an eligibility meeting, and you're told at that meeting that they are going to declassify your child, and they will send you the written notice. If you want to be sure that you make it within the 15 days, you can go ahead and file 15 days from the day that you were at that meeting. Not wait for them to send you the written notice if you just want to be sure. Or you go to the IEP meeting and they give you an IEP at that meeting, a draft, but you want to make sure to get the 15 days, then file within 15 days of them handing you the draft IEP.
Okay, because you can always modify that once you've gotten past that 15 days anyway, correct?
Modify the mediation request?
No, with the IEP in this case.
Oh, yes, yes. Well, yes, you can always have another IEP meeting to modify it. But if you want to stop the IEP or the declassification from going into effect, then be sure and file within the 15 days.
15 days, okay. What if your child has a temporary disability, such as a broken leg, and needs services during that recovery period?
Well, it depends on how long is the temporary. If it's going to be a couple of weeks or 4, 5, 6 weeks, they may not get a 504 plan, although hopefully the school will make an accommodation for them. I mean, if if it's going to require them to be out of school during that time, but I don't think a broken leg would, they might be able to get home instruction as a medical home instruction.
Mm-hmm. Okay.
But if they're going to be in school and it's going to be 5-6 weeks, I mean, hopefully the school is going to accommodate them.
Okay.
If not, ask for a 504. It never hurts to ask for it.
Okay. All right. We've really gone over. I have one more question, and then we'll wrap it up with that one. This individual has a middle school son who is being treated for school refusal. The charter is reluctant to work with the program that the psychologist is recommending. So could you comment on that?
Well, that's not uncommon, but I would see if the charter school psychologist or social worker or special ed director can sit down and meet maybe with the person that is working privately with the student, so that that person can go over, you know, what their background is, what their why they're recommending this, and see if they can work out a joint plan, because it's up to the school and the IEP team to decide what kind of services they are or they're not going to use. I mean, sometimes I don't know if the charter school is fully familiar with this person and what their background is and why they have an expertise in school refusal and why this would be, you know, the appropriate thing to do.
Okay, because, you know, school refusal can be in steps. You know, you get the child to the parking lot maybe and they don't go in, so you do that for a while and then you kind of keep extending it. So so the best thing to do would be for the family to sit down with somebody, psychologist from the school, then, and try and
bring in their person.
And bring in their person, yeah.
Yeah, if the person can't come in, if their outside person can't come physically in, maybe they could be available on the phone to have a conference, because it may be that the charter school just doesn't know the person, isn't sure about it, and so on and so forth.
Mm-hmm. Okay, then I think we're going to end it here. I want to thank you very much for this great presentation, a lot of really useful information. I'm going to hand it back to Kelly for a wrap-up. Thank you.
Thank you.
Thank you all for joining us on our webinar on charter schools and understanding your child's rights. There is an exit survey, which we would like everyone, actually we need everyone to fill out. The webinar blog is now open and available for the next 7 days on our website. Any additional questions that were not covered in tonight's webinar can be, any questions that weren't covered can be posted there and the answers will be archived. Our website is www.njcts.org, and we will be posting a recording of tonight's webinar there as well. Our next presentation, What is Dyslexia and What Can We Do About It? An in-depth look at dyslexia, identification, research, treatment, and outcomes will be presented by Dr. Michelle Hum and is scheduled for August 24th, 2016. This ends tonight's webinar. Thank you, Ms. Spar, for your presentation, and thank you, everyone, for attending. Good night.